Medical malpractice litigation in Canada is a complex area of the law that governs many of the responsibilities healthcare professionals owe to their patients. As a lawyer who practices solely in this field, I'd like to provide a brief overview of what Canadians should know about their legal rights when medical care results in serious harm. Medical malpractice is a subset of negligence. In Canada, there is a legal duty on everyone to take care and avoid placing others at unnecessary risk. This duty carries through to doctors and to nurses who are trained to diagnose patients correctly and treat them effectively. Unfortunately, though, no one is perfect, and over enough time, mistakes are bound to occur. When a doctor or nurse makes a mistake, the person who is harmed has a legal right to bring an action alleging medical malpractice. Exercising your right to bring a malpractice claim, though, is complex in terms of what you'll need to prove and the evidence you'll need to put forward. In order to succeed in a medical malpractice action, the injured person needs to demonstrate that their healthcare professional did not meet the standard of a reasonably careful practitioner in that specialty. It's not enough to show that the care you received was incorrect. You need to show that it was unreasonable. In practical terms, this means that you must obtain evidence from an independent medical expert stating that a reasonable doctor or nurse would have treated you differently. If you have this evidence, you can establish that the doctor or nurse you're suing did not meet the standard of care. That's the first step. The second step is showing that this failure to meet the standard of care is what caused your injury. You'll need another specialized medical expert to review the medical records and determine how the outcome would have changed if the care provided to you was reasonable. This is often very challenging because no one knows for sure what would have happened if the alleged negligence didn't occur. But in successful cases, you'll be able to prove that it's more likely than not that without the defendants failing, the harm you're suing about would have been avoided. A final requirement in proving a malpractice claim is establishing that the harm you suffered is recognized by our courts as being subject to an award of damages. In practical terms, this involves giving careful consideration to what a court would likely award you if you succeeded. In malpractice, you can claim for things like the income you lost as a result of the negligence or the cost of the care you'll need to manage your injury into the future. Proving a case in medical malpractice is challenging, which is why it's important to consult with a lawyer who has experience in this area of the law if the medical care you received or a loved one received ends in injury. At Wagners, we offer free, no-obligation consultations to anyone who is concerned that the care they received was not up to the standards that we should expect of the doctors and nurses we trust to act reasonably and protect our health from unnecessary risk.